Good afternoon, everyone, and welcome back to this week's episode of the Digital Law News produced by Anson Evaluate. I'm Amelia Davies, an apprentice solicitor at Digital Law UK. I'm joined by my colleague Peter Wright, and we're just going to run through some of the news stories that have been coming up this week. I'll pass over to Peter to introduce himself, and then we will get started.
Thanks, Amelia. Yes, we've got just a few things to update everyone on this week. In particular, keeping it topical given the issues around drought across the UK and most of Europe at the moment. We've also got a story with regards to a water company. So I'll pass back to you, Amelia, to kick us off with that.
Thanks, Peter. So yes, a water company has confirmed it was targeted by hackers in a cyber attack. So South Staffordshire PLC, the parent company of South Staffs Water and Cambridge Water, said its ability to supply water was not affected. Posting online, a ransomware group claimed it was possible to tamper with the water supplies. However, this had been disrupted by the water company. And cybersecurity experts have looked at this attack and said that it has set a worrying precedent. And if we think back to the previous podcast episodes we have looked at this year, we have seen an increase in cyber terrorists targeting critical infrastructure. I don't know about you, Peter, but I definitely say water supplies is part of critical infrastructure. So I will pass over to you to continue.
Indeed, they are a part of critical infrastructure. You're quite right, Amelia. And indeed, the protection of the UK water supply from cyber attackers is one of the duties of the CPNI, which is I think it's the Committee for the Protection of National Infrastructure. And they deal with the protection of these sorts of things, everything from water to electricity to energy, transport, etc. And in this instance, we've seen a water company, and let's face it, water companies are somewhat vulnerable at the moment. And indeed, we've seen that in this instance, this one has been subject to a hack. It says it wasn't something that affected water supplies, but I think it does show that when networks are under pressure, and certainly the water system is under pressure at the moment, they've got a lot of negative press coverage from issues with leaks, all the way through to problems when it comes to delivering water supplies, low reservoirs. Indeed, some towns and villages have already found their water supply being cut off during the recent heat wave. Then when customers hear, oh, and they've been hacked as well, it generally contributes to a picture of saying nothing is working properly. And in this instance, it really doesn't help for the press and PR of an industry that's currently struggling. So it's trying to sort of say here, look, nothing has been, no water supplies are affected. But it doesn't really say what sort of data has been affected. So was was bill payer information affected? People's sort codes and account numbers from their paying their bills? Was information where people called up reporting leaks? Was that hacked? I mean, the point here is that it's all different types of personal data which might trigger a report to the Information Commissioner's Office, even though if we're just looking here at the hack, meaning that they lose command and control of the network, that's still a problem. Hence why cybersecurity experts have said that this is a worrying precedent. Yes, it is, and it's worrying for all providers of critical national infrastructure.
I think another key thing to mention here is that the group demanded payment to prevent the release of internal documents to explain how it broke into the network. And specifically here, the NCSC, the National Cybersecurity Centre, have advised against paying the ransom demands. And for those in the back, I believe Peter and I spoke about this in quite a lot of detail last week, but you do not want to be paying those ransomware demands, because at the end of the day, okay, they might give you back the data, but they could also encrypt it and then ask for another ransom. So you'd be stuck in that vicious circle of not ever actually getting anywhere.
Exactly. And then there's also the problem that they could then turn around and hack you again within the next hour, the next day, the next week, because the vulnerability that meant that they hacked you the first time is probably still there. So yeah, don't feed the hackers, don't pay the ransom is the overarching message. Far better to make your system properly secure than to leave a vulnerability and just continue to pay out more and more, particularly at a time when the money supply could be getting quite constricted. It's not really worth paying that to hackers.
Thanks, Peter. So moving on to our next story. So Chinese internet giants, including Alibaba, TikTok owners ByteDance and Tencent have shared details of their algorithms with China's regulator for the first time. So if we think back to our story last week, this is where we looked at the UK Parliament shutting down their TikTok account due to the fact that there was a lot of data that could be discovered here. And we were mentioning how dangerous this could be if Chinese government and Chinese regulators saw this. And lo and behold, the gift that keeps on giving, this week's story is mentioning how TikTok, ByteDance, they have been sharing their algorithms to look at the growth of the social media platforms. So I will pass over to Peter to go through this in more detail.
Thanks, Amelia. I mean, I think the easiest thing we can say here in terms of the description of what's happened is that, you know, the algorithms for these platforms are crucial in terms of how they operate. In the US, Meta, parent company of Facebook, and Alphabet, parent company of Google, have strongly resisted potential moves to say that they should disclose any of their algorithms to any of the US regulators, such as the US Federal Trade Commission. And they have said, you know, this information is ultimately a trade secret that should not be disclosed. The difference here is that we are not talking about a liberal democracy such as the US. We're talking about the authoritarian Chinese state. And guess what? When the Chinese state turns around and says, we'd like to see the algorithms that you, a Chinese corporation, have developed, basically the response is that they will produce that algorithm along with anything else that the state wishes to see if it knows what's good for it. So the point here is that they're going to provide things like algorithms, they might provide access to data, they would open up systems, all of the things where you might argue that privacy and the right of the individual trumps the right of the state to interfere. Well, that simply isn't a thing in China or in any authoritarian state. And in this instance, the regulator has said, we want to see these algorithms, and the companies have gone, yes, here you go, would you like anything else? So it kind of shows the different approach here. And as you quite rightly say, Amelia, this is why we should not be using these sorts of platforms, certainly for business related activity. So hence why the UK Parliament last week was correct to swiftly close down its TikTok account. And it's a similar warning, I think, for any organisation that is thinking of using these platforms for certainly sales or marketing or communications purposes, is to think again. Really, it's one thing to be using insecure platforms like Facebook, WhatsApp, Twitter. It's quite another to go down the route of using these Chinese platforms where, in effect, they are an extended arm of the Chinese state, and that data could be used for multiple nefarious purposes, and you'd never hear about it. Indeed, I'm surprised that they were as public as this in terms of the fact that those algorithms were handed over to the state by those Chinese companies. But also this kind of proves a lot of what was being said a year ago, 18 months ago, when there were concerns about Huawei, the 5G and telecoms provider that's provided infrastructure underpinning broadband networks around the world, including the UK's 4 and 5G network. The argument was always that if the Chinese state tapped them on the shoulder, that Huawei would end up giving access to the Chinese state to various things, even if the countries where that hardware was being installed wouldn't want a third party to state to have that sort of access. In this instance, when the Chinese state turns around and says we'd like to see that, a Chinese corporation is always going to give them the access. And that's one of the key takeaways here. So hence that the concerns that were held around Huawei were clearly right. Concerns around TikTok and its use were clearly right. And I think anyone considering using a platform in China has to be aware of this. Also be thoughtful and careful about this if you are using having a platform that may, on the face of it, be a Western corporation, but uses cloud storage or infrastructure based in China. And Zoom fell into this platform before the pandemic, when it was found that it had been using Chinese infrastructure, servers, etc., to provide low-cost extra storage and processing power as it rapidly grew its network. And again, if it's being stored on a network in China, guess what? The Chinese state can have a good look at it. So again, if you are a highly regulated entity, then you certainly should be thinking twice before using any of these platforms for business-related activities.
I think that's a key point, Peter, as well, is when you're saying, if the Chinese government taps you on the shoulder, you need to be giving this data. But what sort of data are they going to be giving you access to? Allegedly, the Chinese version of TikTok, their algorithm actually detects what users click on, comment, like, and dislike, which potentially then, if you can see that, does it not mean that you can see the users themselves? And if you are tracking their likes and dislikes, there is a whole rabbit hole of details that you can collect on them. Not to mention the fact that I believe we covered this in a few previous podcasts, where if you've got this sort of data about people's likes and dislikes, you can very easily create a profile on them, which can then be used against them potentially if we're talking about the Chinese state.
Yeah, and you make a good point there, Amelia, about the richness of the data that these systems collect. Bear in mind, sometimes when you're using a smartphone that's slightly older, it starts running out of space. And you sometimes have to consider, oh, I need to take some apps off the phone. And of course, the biggest apps that take up the most space are things like Facebook, LinkedIn, TikTok, etc. Those apps are incredibly invasive. Sometimes it's not just analytic data from your use of that app in terms of which videos you've looked at, comments you've made, things you've liked, places you've scrolled to. It could even be that some of these apps sometimes are collecting wider information from the device, such as GPS data. So where you travel each day, every day, when you go and see family, when you go and see friends, when you go to work, when you go to the shops, when you go out in the evening, where you go to in the morning for a coffee, all of that information potentially being collected. Things like text messages, your SMS messages that are just being on the phone. Sometimes these apps are looking at those. Sometimes they are looking at your phone calls, the people that you're calling, how long you're on the phone for. And I mean, Amelia, you make the point that, well, look, could they even be looking at through the camera, listening to it? Well, we don't think they are. But there is a very rich tapestry of information that our mobile devices collect anyway. And some of these apps collect, access and collect that sort of information. And then these algorithms look through it for various purposes. And if it's the Chinese state looking at that, well, take a wild guess. They're doing that generally for reasons of nefarious reasons of surveillance. Don't forget that the Chinese state is that the people there are amongst the most widely surveilled in the world, because all of the Chinese apps, platforms, etc., are wide open to surveillance and used by the government to keep their people in check and to crack down on any forms of dissent. This is what they don't like in Hong Kong, where the change in the security law now means that people who were used to using Western apps and having Western freedoms are now finding that they actually know that it's being shifted into more like what it's like on the Chinese mainland. And that's a bit of a shock if you've been used to living in more of a sort of Western style democracy. So these are real concerns, and I don't think that in the West we've really sat up and taken notice of it. And it's when we see stories like this that it really does ram the point home that you really need to think about where the apps that you use every day have come from, and think about the richness of the data that they are collecting. Also think about, for example, do you need to have these apps on multiple devices? Is it worth just having them on one phone rather than having on your phone, your tablet, your laptop, business phone, personal phone? Really do limit the use of these things because they are watching you all the time.
Thanks, Peter. So moving on and staying with the richness of data. So last week we went into quite a lot of detail in relation to the NHS 111 attack. And this story is very closely related. So there are data privacy fears as GPs are sharing patient records on Word documents via email following this cyber attack. And this is with the fear that they could very easily be intercepted by hackers. So essentially here, where the NHS 111 system, patient records were majorly affected by this cyber attack. And therefore, in a way to get around this, GP services came to the agreement that they would be sending patient records in Word documents via email. And as a law firm, this is essentially a big no-no for us. We share everything with our clients via a secure portal for the purpose of the fact that we are a highly regulated area, and therefore when we are sharing documents which may well be rich in personal data, we need to make sure that this is secure. And this is the main problem here, because if you're just sending this through a generalized email platform, and that's another issue that no doubt Peter will unpack later, there is every chance that this data could get into the wrong hands, even if it's not just an attacker. It's so easy to simply email the wrong person the patient records, and if you end up sending the patient records to, say, your spouse, it's probably not going to end well there. So I'll pass over to Peter to unpack this further.
Thanks, Amelia. I mean, you've actually covered the main points there, because this is far from ideal if email is being used for this purpose. And I mean, it's interesting that, in particular, this has referred to an incidence of this happening in GP practices in Liverpool, and the excuse given there was, well, this isn't ideal, but in some instances it's better to send the medical records so that the doctor providing the treatment can at least look at that person's records and just check. I mean, if for example, your patient is presented and they might be unconscious, they could be ill, and you need to check for an allergy before you give them some medication, otherwise it might kill them, then you think, yeah, it probably is worth just checking the medical records. And if we have to do this quickly in order to save life or improve life chances or stave off the possibility of life-changing injury, you'd think, yeah, get on with it. And you can see why that would be the overriding objective in this instance. I think the problem is where it becomes habitual and routine. If we're talking about, dozens or hundreds of people's individual medical records being shared by a Word document through email all day, every day, because it is very easy for usually email accounts to be hacked. Think how often people use passwords that are easy to crack. For example, password or 123456. All it takes is being able to do that to then hack into someone's account quite easily and look at this highly sensitive personal information. As you quite rightly say, Amelia, sometimes there could be information on your medical records that you have not shared with anyone else because it's no one else's business. But if that then gets hacked, that's going to be a fairly massive invasion of privacy, and you could be blackmailed with that information. Or it could just be very embarrassing if that information were to be broadcast to the whole world. So this is an important issue, and it also highlights the lack of a clear digital infrastructure within the NHS. Back in the deep and distant mists of time, back in the first 10 years of this century, the UK NHS was in the process of having this multi-billion pound digital IT system set up. Arguably, the vision exceeded the infrastructure and the ability of the government to deliver on a large-scale infrastructure project. Billions of pounds was lost in PFI, private finance initiative funding, and the whole system ended up being cancelled. There were just little bits of it here and there that ended up being implemented, but this whole big digital strategic vision never happened. And that's why we've now got to the point where we have a National Health Service under more stress than ever before, with waiting lists covering 10 million people. That's basically almost just over 1 in 7 people in the UK waiting for treatment in some way, shape or form. And we're relying on old paper records. We're relying on, in this instance, email and Word documents, when you really would think that the whole point out of having something like a unified National Health Service means you could have a widespread, secure digital system that would allow the whole thing to operate, and that records could be easily shared from a GP to an NHS trust to an accident and emergency unit, or even be sent digitally to a paramedic in the back of an ambulance trying to save someone's life, that they will be able to then look at securely on a 5G network that patient's records and use that information when trying to save them. You'd think it would be easier. We aren't talking about the sort of the proliferation of lots of different health providers as you get in many other countries. But sadly, in this instance, the UK government's winning touch with IT procurement, which is dire, has struck again. And that's why we've got local GPs and local NHS trusts relying on technology that, in this instance, simply isn't fit for the purpose of sharing properly that highly confidential, highly private medical information that you'd think should be shared securely. There simply isn't the correct way of being able to do that available in this instance.
You certainly mentioned there in the fact that a lot of the critical infrastructure is just not there. But there's also the fact that if you're sharing documents in this way, there is a lot of room for human error, because not all breaches can actually come from cyber attacks in themselves and hackers. It is so very easy to make one small mistake, and then essentially those files could end up in nefarious hands through no fault of kind of technology side. Just simply you've typed something in slightly wrong.
Absolutely right. So think about the stressed GP receptionist who's fielding hundreds of calls during the day and who's trying to send the medical records in response to a doctor's request, and with one incorrect keystroke could end up sending sending the records to the wrong person or copying in the wrong person. Think of, in the same way, other stressed members of the NHS who are doing their best in a difficult circumstance at the moment. The potential for human error amongst stressed, tired individuals is going to be commensurately higher than it otherwise would be. And hence this sort of risk is going to be exponentially far greater than it otherwise would be.
Thanks, Peter. So moving on to our next story. So this is in relation to cryptocurrency and the UK courts. So the UK Court of Appeal is to hear Tulips' trading case on legal duties owed by a blockchain developer. So the English Court of Appeal will hear Tulips' trading case on granting permission to appeal the High Court's decision to strike the case out because of lack of jurisdiction. So essentially here, an individual had argued that when he had been hacked and therefore lost his cryptocurrency, that the provider should owe him a duty of care and therefore potentially give him back some of his crypto as a result of this. And while initially the individuals involved relating to the crypto provider, they are actually outside the UK jurisdiction, hence why the High Court has actually struck this out. So I will pass over to Peter to mention why this is very important when we're talking about crypto regulations.
It is. This is a really important case, Amelia, as you say, because we are looking at very often an increasing number of very high value transactions taking place using cryptocurrency and based on blockchain technology. So look at some of the high value transactions that take place using NFT, non-fungible tokens, as well as cryptocurrency trading that takes place relying on blockchain. And the point here is that if you then encounter a problem during the course of your high value trading or the high value thing you think you're getting in terms of your NFT, you suddenly find that you've not received the product or service that you thought you were. What do you do? And in this instance, so far, the High Court has said that, look, of all of the developer defendants here whose blockchains were being used, it was stated that the claim was struck out because they were saying, look, they either they're out of the UK jurisdiction or out of the jurisdiction of England and Wales, I should say, or they simply lack. So it's not that they simply aren't in the UK. In many instances, they aren't actually domiciled in any country or state. So they're actually evading the rule of law, actually evading the responsibility of courts and laws. And I mean, sometimes I think with sort of digital transactions, the temptation to think, oh, we don't need to be bound by boring, tedious things like banks and currencies and laws and contracts. We can just press a button and it's done and it's secure and it's fine and you can rely on it. Well, what if you can't rely on it? And then that's generally the reason why over the course of 1,000 years, we've evolved things like courts and laws and things so that people can have some form of redress. And in this instance, I think it's quite important that even if we are saying, look, potentially these developers are outside of jurisdiction, that does an individual actually have the legal right of redress? That's what we're actually talking about here. And so while this case actually comes down to an issue over an individual who's was undertaking trading and then was hacked and lost a large value of Bitcoin, the wider point is can these developers whose technology is being relied upon, can they then be subject to redress from someone who potentially suffers a loss as a result of relying on their technology. It's quite a fundamental point. If you were driving in a car and the wheel fell off and someone suffered injury, you can sue the manufacturer. But if it was something to do with that, or you could sue the garage if it was them that attached the wheel, you'd have a way of being able to deal with an issue whereby there would be a mean of redress and holding someone to account. And very often now with digital transactions, that is not the case. So this is an incredibly important principle here. And it's therefore, I think, quite right and proper that the Court of Appeal is looking at this. I mean, they might uphold the decision in first instance of the High Court here and say, no, these entities are simply beyond the reach of this jurisdiction. Or they might actually say that, decide to say, well, no, they aren't necessarily in anyone's jurisdiction, but they are, in this instance, we are willing to sort of look behind that veil and actually allow for steps to be taken in court. So either way, the decision of the Court of Appeal on this is going to be quite crucial and will set a precedent that we'll end up relying on certainly in the short term.
Thanks, Peter. I think it's key to mention as well, so the initial High Court case, Mrs. Justice Falk found in favour of the developers, finding that the individual had failed to show that there was a serious issue to be tried on the question of the existence of duties. However, now that Tulip Trading has permission to appeal, a hearing will be set for the parties to argue that decision to allow that the challenge was an error. If so, the case will actually end up going to trial, and it will likely be a 2-day hearing where the notified parties will then have to kind of come forward in due course. So it'll be interesting to see here what the outcome of the appeal will be, and no doubt we will end up covering this in more detail when we get those coming through.
Indeed, that's sort of an important point there, Amelia. I mean, it's interesting to see what the position of these 16 developers is. Would one or more of them turn around and think, well, we aren't domiciled in the jurisdiction of England and Wales, so we aren't actually going to bother turning up and defending this. And even if you enter judgment against us, either default or summary judgment, we could turn around and go, well, tough, we aren't based in your jurisdiction, your judgments mean nothing to us. Or would the fact that would have a commensurate impact on things like international credit ratings, would that mean that they would invest in properly defending and arguing this case? It's almost like if they turn up and argue and defend it, does that mean therefore that the court does have jurisdiction? So these are the sorts of questions that need to be asked when it comes to the wider operation and use of blockchain technology. And hence why this is a really important decision that we'll be looking for from the Court of Appeal. I think it would actually be good if it did allow for the action to go ahead, and we then did have a potential 2-day trial that follows.
Thanks, Peter. So that was our last news story for today. A big thank you to Anson Evaluate for helping to produce this webinar, and we'll be back next week. So just a reminder that these episodes are available on our website, our YouTube channel and podcast channels as well, such as Spotify and both Amazon and Apple Music. Thank you for listening, and we hope to see you again next week.